Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, we are in that time of the year where the Supreme Court has a few slots remaining for what would be the spring docket in 2025. They've already given thumbs up to a handful of cases and a lot of thumbs down to them. Digging across some of those petitions for certiorari, came across a petition by the Firearms Policy Coalition in an issue that really is not getting any attention. And candidly, when you see what the issue presented is, when you see what happened here, and when you begin to understand what could be done with it if it's not stopped now, yeah, this turns out to be an immensely important Second Amendment case. But no one's talking about it. Maybe we should be. So let's start doing that today. We'll geek out on the petition for certiorari. So today, let's spend a few minutes and let's talk about the Supreme Court petition no one is talking about, but they should. What do you got there, man?
TacPack.
Oh, sweet. A TacPack? Nice.
Oh, what's a TacPack?
That's the new sponsor of the channel.
So what's in a TacPack?
Oh, what's in a TacPack? Well, here's the best thing. It is a monthly subscription of all sorts of tactical gear. And I mean, they got a lot of really cool stuff. The best part about it is that they actually have two separate subscription models. So they got their TacPack Standard, which ships at $59.95 a month. Best thing about that is it really has a value of about somewhere between $90 and $120. And then they got the TacPack Plus. Now that ships at $139.95 a month, but, oh, check this out. They actually have a value of somewhere between $240 and $300.
Wow, that's pretty cool.
Yeah, it's super cool, and here's the coolest part yet, because if you sign up right now for the TacPack Plus and you use the promo code GunLawYT, you're going to get an extra $60 everyday carry kit, which means that your initial investment for less than $140, you're going to be ended up getting over $300 worth of tactical gear. Listen, look at some of the cool things you're going to get if you subscribe to TacPack today. So get down there, check out the link below, make sure you use the promo code GunLawYT. Check out TacPack. Okay, America, the case we're talking about comes out of the state of Michigan. It is entitled Oakland Tactical Supply Incorporated v. the Howell Township. The whole facts of what led to this could be a subject of at least a 20-minute video. I'm going to try to condense it for you real shortly, okay? Inside the Howell Township, there is a large piece of property. Apparently has an abandoned rock quarry on there, and many of the residents have used it for years as a shooting range, okay? And the town has had no problem with individual residents going out there and using the property for private shooting. Along comes Oakland Tactical Supply Incorporated. They purchase the land and then they say, hey, you know, this is a great piece of land, really well suited for shooting here. We're going to build ourselves a commercial range, which one would think that as the property owners, they have every right to do, especially since, you know, everyone's been shooting on the property forever. Well, that's when the township steps in, basically through zoning says, no bueno, not going to happen anywhere, and essentially blocks the plaintiff here from ever establishing that range through zoning. So the lawsuits start. Now, at the trial court level, the plaintiffs here, they lost. They make it all the way up to the 6th Circuit, okay? And at the 6th Circuit, they still have lost. And what do I mean here? What I mean here is that the 6th Circuit has actually ruled that you can't really infringe anyone's Second Amendment rights through zoning laws, okay? Now, if you want to know just how important this case really is, the issue presented by the plaintiffs here, which includes the Firearms Policy Coalition, is whether the Second Amendment presumptively protects against restrictions burdening the right to train with firearms commonly possessed for lawful purposes. Well, that sounds like a pretty important issue, and in fact it is. And kudos to the Firearms Policy Coalition for picking this fight. We're going to put a link for them down below so that you guys can all show them some love. Now, what we're going to talk about today is a little principle of argument called framing the issue, okay? Because I just read the issue presented, and when the issue is presented just like that, well then, you know, it's pretty easy to reach the correct conclusion. But if the court doesn't want to reach that conclusion, if somehow or another they are more oriented to coming to a contrary conclusion, well, what they're going to do is they're going to reframe the issue. And that's exactly what happened here and how the 6th Circuit got to this really terrible ruling. But so you understand the importance of this issue, Let us not forget, as the Firearms Policy Coalition states, just as the freedom of the press encompasses the concomitant rights to purchase paper and ink, the Second Amendment right to keep and bear arms encompasses closely related acts necessary to its exercise, including the right to take a gun to a range in order to gain and maintain the skill necessary to use it responsibly. Now, to give you an idea of just how poorly the courts have framed the issue, even though the Firearms Policy Coalition and the plaintiffs here have made it pretty clear. Now, this is a pretty simple issue, which is, can you ban Second Amendment activity in an entire township through zoning laws? That's really the issue here. But as the plaintiffs point out here, the panel refused to define petitioner's proposed course of conduct as simply training with firearms that are in common use. Instead, the panel insisted that petitioners could prevail only by demonstrating that the Second Amendment's text protects the rights to train at a commercial facility anywhere in the township. Okay, and not only is that completely absurd in misframing the issue, as it turns out, it's also in contradiction of two other circuit courts, one of which is the Third Circuit, not really known for being particularly pro-2A, and then the Seventh Circuit. We already have talked about the Seventh Circuit, how much they hate the Second Amendment, and yet they have found contrary to the Sixth Circuit here. So with that circuit split, you can understand that this case now has a much higher likelihood of being accepted by the Supreme Court. As FPC points out, that line of reasoning is flatly contrary to the analysis of the Third and Seventh Circuits, which have correctly explained that zoning rules restricting the location of firearm ranges implicate the Second Amendment, even if they fall short of an outright prohibition of gun ranges. And see, here's the issue, okay, is that if zoning laws never, ever, ever implicate the Second Amendment, you could see how some of these local jurisdictions and then result-oriented courts could literally completely alleviate any type of Second Amendment activity within particular jurisdictions. And then, if the state legislature on top of it puts all sorts of mandatory training that you must accomplish before you can actually get a license to then get a firearm, and there's nowhere to train, aha, now you see where they're going. As FPC, again, correctly points out, the panel majority's reasoning, if allowed to stand, would have a deleterious effect not only on the right to train, but on other necessary incidents to the right to keep and bear arms, such as the right to acquire firearms and the right to store firearms in an accessible manner. And that's the other thing that we oftentimes fail to recognize, is that gun ranges provide a lot more services than just, hey, giving you an opportunity to run lead down range. Okay, there's a lot of training, there's a lot of retail operations, there's a lot of other services that are offered at reputable gun ranges. And as usual, whenever a court comes up with some kind of a ridiculous test that it just makes up out of thin air, as was the case here, well, what they're really doing is they're injecting the interest balancing back into the equation that the Bruin case clearly exercised out of that equation. So as FPC had to point out, like some ghoul in a late-night horror movie that repeatedly sits up in its grave and shuffles abroad after repeatedly being killed and buried, the panel majority's opinion thus causes interest balancing to stock Second Amendment jurisprudence once again. And so the problem from this case was from its inception. Because when the court chose to misframe the issue into, well, is there any historical analog that says that a person is entitled to have a gun range anywhere they want, anytime, anywhere, any place inside their township, which was not what was being asked here, okay? And so as FPC again has to point out, the panel majority here adopted a bizarro description of petitioner's proposed conduct, narrowly defined in terms of the particular range Oakland sought to construct, the commercial operation of a 1,000-yard range. And it concluded that there was no textual or historical evidence that the plain text of the Second Amendment covers this formulation of plaintiff's proposed course of conduct. And that is exactly how other courts will continue to rule unless the United States Supreme Court steps in and does something about this. And the problem is this deals with zoning laws, okay? And one need not really have a very vivid imagination to understand what local jurisdictions could do to your Second Amendment activities through zoning laws. And it's for that reason that this petition, which has really gotten no attention whatsoever, probably all ought to start getting some of our attention. Okay, the case once again is Oakland Tactical Supply Incorporated v. the Howell Township. We're going to link up FPC's petition down below. Great work. Link for them to show them love is also down below. Now listen, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information, it's down there in the description box. Maybe you got an idea for a video we should be doing around here. If you do, go ahead and click on that link and let us know. It's probably better than any idea we'll come up with. Maybe you just want to be part of our monthly subscription to the newsletter. Hey, the ability to subscribe to that is all down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.